7:40 on CKNW. Thanks for spending some of your morning with us here on the John McComb Show. We appreciate that. Our Boughton Law legal series continues now, and we're going to talk about an issue or issues that revolve around employment and how employers deal with employees. Plenty of pitfalls for businesses in terms of employment law and what have you. To help us do that, we're joined by Elizabeth Reed. She is a human rights and employment lawyer with the Boughton Law Group, and they are partnering with us this year to talk about, legal matters that come up in everyday life, and this is certainly one of them. Nice to see you. Thanks for coming in.
Thanks so much, John. Great to be here.
So who would be interested in this? Who needs to pay attention now?
Well, it's helpful for everyone, but I think probably the focus of our work is always on the employer side. So small businesses, in fact, we act for businesses of all ranges. So everyone from your mom and pop shop right up to global corporations. And
why is it necessary?
Well, I think the most important thing to think about from a legal perspective is always sort of prevention and preparation. Because to put it pretty frankly, you can pay me a lot less money at the start of the employment relationship than if you don't do things right from the beginning and you end up into trouble later.
And well, let's start there. What kinds of situations do, right from the get-go, right from the hiring part of the relationship, what kinds of pitfalls do companies get into?
Well, the biggest mistake that I see is not having a written employment contract. And there are lots of reasons that people are afraid of having a contract. They think it's going to be too expensive. You know, they don't want to have someone come in and put down this sort of 3-inch thick piece of paper in front of them and, sort of scare them off right at the beginning. But you can have a very simple employment contract that sort of sets out the expectations for the employment relationship, and that can really keep you out of trouble down the road.
So would you suggest that every employee have some kind of written contract, some kind of a deal?
Definitely. And
really?
It doesn't, as I say, it doesn't have to be complicated. You can have, it's perfectly appropriate in a lot of situations to have a 1 to 2 page hiring letter that deals with basic things like how much are you going to get paid, and most importantly, what's going to happen if you have to let that person go.
So you would set some expectations. You would talk about income, vacation, all of that kind of stuff is down on paper. So there's no problem with it as the relationship continues.
Exactly. I mean, ideally, you're going to put that contract, in the desk, and maybe you don't even have to look at it again. But as soon as something goes off the rails, it's really great to be able to go back there and say, okay, you know what? Unfortunately, this relationship isn't working out. This is what we agreed we would provide you if we had to terminate your employment. And then there's no question. You don't have to come to me and say, well, how much notice do we have to give them? What does the Canada Labor Code say? What does the Employment Standards Act say? Are there any human rights issues? We've sort of got a lot of it set out in advance.
I think a lot of people, especially, employers and employees both, in many cases don't really understand what set of regulations they're working under, whether they're provincial or federal, and what the law actually says in terms of what their rights are and what their expectations are.
I think that's very true. And in particular, the biggest thing that I find people don't know about is a lot of people are familiar with the basics of, for example, the Employment Standards Act that regulates provincial employees. But the law that people aren't familiar with is the common law. And that's basically the law that judges have made over the years. And essentially, you're going to have an employment contract even if you don't have anything in writing. From a matter of law, as soon as you say, I'll pay you $10 an hour to come clean my house, you have some kind of a contract. So if you don't write down and sort of say what the terms are, then the common law is going to imply those terms. And the biggest sort of common law term that gets implied is a term of reasonable notice. So unless the employee has done something really horrific, you have to give them a certain amount of notice in advance if you want to terminate their employment. And that's one that people often don't know about.
And what kinds of situations would indicate that a person could just be fired? I mean, it has to be something pretty egregious, doesn't it?
It does, definitely. one of the big challenges, what we call that sort of in a legal parlance, is a termination for cause. So when you have a termination for cause, it does have to be very extreme. Things like theft, assaulting another employee, those kinds of things. If you come in and tell me that's happened, I can usually say, okay, yeah, we can fire them for cause. You don't have to pay them any notice. They're out the door. But it's always going to be contextual. So if it's, $5 out of the petty cash when the person's been with you for 30 years, that's not going to be cause.
Yes. Well, let's talk a little bit about once a person has been hired and the employment relationship is moving along, and then something happens, a difficult workplace situation comes up, whether it's performance, whether it's lack of social skills. You mentioned theft, insubordination, all of those kinds of things. How does an employer deal with that? What can and can't they do, or should they do?
The most important thing to do is to deal with it. And that's one of the biggest mistakes I see employers make is they're uncertain about how to proceed. They're a little nervous. They might be conflict shy. And so they don't do anything about it. They don't say, you know what, I've noticed you're coming in 15 minutes late every day, and then soon it's half an hour. And then when you've been putting up with that for a year, it's pretty hard to go back to the employee and say, you know what, this is not okay. We need you to change this behavior. You want to be able to start with that staged process and start with just the conversation that says, John, I've noticed you're coming in 5 minutes late every day. We need to talk about your start time. Versus a year and a half later, and you're going, well, Elizabeth, come on. I've been coming in 5 minutes late every day. Why now? What's going on?
Yeah. Get on top of it.
Yeah, exactly.
What about, I've worked in this business, the broadcasting business for 45 years. And over that time, it seems to me that a lot of the problems that arise between employees and employers really boils down to personality issues. Really is about people just knocking heads, people who, for whatever reason, can't get along, or a person who can't follow direction, those kinds of things. So how much more difficult is it when it's people butting heads, and it's all about the personality clashes, because they certainly go on.
The personality clashes are challenging. I think that if it can be resolved, I think the way that you can resolve those sometimes is to try to find out what's driving the behavior. So what's behind that clash? And sometimes it's, because someone's feeling a bit of a lack of respect for themselves, so they feel like they've got to be really aggressive and push things. Or, the manager's feeling like nobody listens to me. And maybe it's just that the employees don't know why that particular rule is important. So some of those personality things, can just come down to we need to figure out what each person's interests are and see if there's a way we can kind of merge those interests or build on some common interests that they might have to help sort of mitigate that. If it's really entrenched personality conflict, that one, you might just be looking at parting ways. Yeah,
and it's so different from the old days when it was, it was the boss's way or the highway. If you didn't like it, get the hell out, or you'd be fired right on the spot. Just get out. Pick up your last paycheck and get out. And it literally happened all the time. Now it's a little bit more, there's more process involved than that. Let's put it that way.
Yes, there is a lot more process involved, a lot more regulation, a lot more rules to follow for sure.
We'll take a pause. When we come back, how do you terminate an employee? What do you need to know if you're a business owner? What should you and should you not do? We'll continue our discussion with Elizabeth Reed. Boughton Law is CKNW's on-air legal analyst for 2015. They're joining us throughout the year to give us the lowdown on legal solutions in business and in life, and also joining us to explain the legal implications behind some of the biggest stories we cover. And our discussions do not constitute legal advice. Much more coming up with Elizabeth Reed after this on News Talk 980 CKNW. And we continue with Elizabeth Reed in our Boughton Law series. We're talking about the employment or navigating the employment relationship. We've talked about hiring and some of the difficult situations that come up in the workplace. And let's talk a bit about terminating an employee. There are good ways to do it, I guess, and there are bad ways to do it. What are some of the bad ways that are going to get employers in trouble?
The bad way of doing it is always to do it without any consideration for how it's going to impact the employee. Because every employee is going to be upset if you fire them.
Sure.
That's just a given.
Yeah.
But the courts don't compensate for that. They just, they realize that, well, of course, nobody's going to be happy about being fired. But if you do something that sort of makes that termination unduly insensitive, you terminate them on their birthday. You
Oops.
call them all kinds of names when you're terminating them.
Yeah.
You make racial slurs when you terminate them. Those are the kinds of things that are going to get you into trouble. So the key thing is, if you're going to terminate someone's employment, you've got to plan it in advance. And I tell employers, bend over backwards to make it as easy for the employee to be terminated as possible. Keep the meeting quick. Don't have it in a public place where the other employees are all going to see them, be fired and walk out in tears. Make sure, even give them some money for a cab for them to get home. Let them leave right then. Don't make them clean out their desk right that second.
Yeah.
Those are the kinds of things, if you have to terminate someone's employment, if you can do it in a respectful way, that will really help. Because I've had I work for employees too, so they come into my office and they say, well, it's kind of harsh that I got fired, but they were pretty nice about it. That employee is probably going to give me very different instructions when I'm negotiating for a severance package.
Well, and it seems to me, not to be too crass about it, but that a person will respond to being dismissed positively or negatively, depending on what kind of severance package they get, what kind of separation agreement they get. If you fire somebody and say, well, here's a couple of weeks, they're not going to be very happy about it. But if you give them some time to transit, find another job, then I think people are a little bit more understanding.
That's exactly right. And part of that goes back to setting out those expectations at the beginning.
Yeah.
So if I have a written employment contract that says I'm going to get the employment standards minimums, I know after 8 years, I'm going to get 8 weeks. And in those cases, probably the employer is going to give me a little bit more in exchange for a release of any claims so that we can both walk away. And I'm going to be pretty happy because I'm thinking, well, that's what I contracted for. That was the deal.
Yeah.
If I don't have that, I'm thinking 8 weeks after 8 years? That's ridiculous. There's no way I'm taking that.
And a lot of wrongful dismissal claims, when they are filed, seem to boil down to whether the person feels they've been treated with respect. I mean, there are money issues, but if you're just kind of dusted off and dumped out the door, that's going to have a big effect on your decision of whether you're going to go after the employer.
It definitely does. Of course, the money is an important aspect, but how hard someone's going to fight, how easily a matter's going to settle, will be strongly impacted by how that relationship was separated. And the less contentious it is, the easier it is to negotiate a fair settlement, the cheaper it is for everyone to, get things resolved and walk away.
And if anybody has any questions, you have the answers.
I sure do.
Elizabeth Reed, you can contact her at Boughton Law. Thank you for coming in this morning. I appreciate it.
Thanks very much, John. Great to be on the show.
And Boughton Law is our on-air legal analyst for 2015, joining us to talk about legal issues in business and life, and also you'll hear them talking about some of the major stories that we cover as well. And a reminder, our discussions do not constitute legal advice. If you want to find out more, and I'm sure you do, you can go to cknw.com/Boughton Law for more information and to replay the interview.